Your Honor, we are aware you have been involved quite a few of the licensing discussions during this conference in Taiwan. I wonder, would you like to share your view on licensing referred to SEP, the Standard Essential Patent?
Thanks, Professor Wang. It's a problem which became more and more important in the last time after the big sell-out by the big companies, for example Nokia and Ericsson, because a lot of standard essential patents are on the market and are bought by some companies who are only interested in making it to money and not to produce things by their own. And therefore we have to regard that these companies who bought the SEPs are mostly not companies where a settlement is possible. And therefore we have a lot of actions against these SEPs. And if you look at the mobile telecommunication, you have normally worldwide standards which are very important, and everyone who wants to participate in mobile telecommunication has to respect these standards, and so he normally infringes the patents. And for this reason, after the decision of the European Court of Justice 2015, we have the FRAND regulations which are broadly applicable, and I think that's the most important thing regarding these SEPs. So you might know it, after this decision every SEP owner has to grant a license for the same conditions as he granted it to others. But normally there is still a dispute, because in the normal case you don't know which conditions your competitor has, and so it's still a big problem.
Thank you very much for sharing the view on the SEP in Europe. After the last month case, the patent international exhaustion arose a big debate. We wonder, in the patent exhaustion within the EU or Germany, what would be the current views and preference?
There is nothing special, neither in Germany nor in the European Union. There are the normal regulations applicable, like if you buy a good which is patent protected, then the patent protection exhausts on this good only. So I think there is nothing special to see. More important problem, I think, are the injunctions, especially if you have injunctions based on SEPs, because an injunction is the most dangerous thing for the sued party, because even injunction which is not lawful can kick you out of the market, and therefore especially in Germany the courts are very cautious now nowadays with granting of injunctions, and normally they wait for at least one decision about the validity of the patent. And first, after the invalidation decision, they will grant an injunction.
Thank you very much for sharing your view, and we hope these opinions will give some guidance for the company in Taiwan and in Asia. Thank you very much. We look forward to have another very meaningful conversation with you very soon. Thank you.
It was a pleasure.
Thank
you.